Alrighty, folks, looks like we are live. I'm George with Solo Suit, one of the founders. Happy to be here on today's show. We are going to be talking about how to win your debt collection lawsuit. We're going to spend most of the time responding to questions that you put into the chat. There's lots of folks on the show here, so there's lots of questions in the chat already. We have my friend John Skiba here with us today. How's it going, John?
It's going great. Glad to be here.
Great. Fantastic. John, how about you tell us a little bit about what you do?
Yeah, sure. No, I'm an attorney in the state of Arizona, and I practice primarily dealing with consumer debt issues. I help people with everything from bankruptcy to defending. I do a lot of defense of junk debt buyer lawsuits, LVNV Funding, Midland Funding, those kind of companies, and even dabble in a little debt settlement and FDCPA stuff. So yeah, I'm here in the Phoenix area. I also have a YouTube channel called Consumer Warrior where I talk about these things as well, and also do kind of a deeper dive into the bankruptcy practice as far as ways to deal with debt. But that's me and what I do all day.
Fantastic. That sounds great. All right, folks, and if you're here, you probably know that Solo Suit helps you resolve your debt lawsuit, so you can use us to create an answer document to respond to a lawsuit. You can also, once you respond, you can also use this to make an offer to settle and get the debt settled with the collector. All right, so that's the rundown. We have lots of questions and lots of folks on today's show. If you have a question, just put your question into the chat. We also would love to hear what state you're in. If you just, there's a lot of people on, just go ahead and put in what state you are in the chat. I'm in Utah, so I'm going to go ahead and type that in here and put that in the chat. All right, just jumping right into the questions. We have one from Tiffany. Is there a threshold under which a creditor is likely to dismiss a case if a motion to compel arbitration is filed? Meaning, is there a certain amount that is likely to cause a case to be dismissed?
Well, I mean, I can, from my experience, I mean, what you have to look at is what it costs for the parties to participate in private arbitration. And I was actually just looking at this with a client today here in my practice here in Arizona. If you're going through the American Arbitration Association, the fees for the consumer are about $200, but the fees for the business or the creditor, right out from the get-go, they're running about anywhere from $2,500 to $3,500. So, if you're in arbitration, I don't know if a creditor who's suing you for less than that amount, for $3,500, if that's something that they're going to be really enticed to do, because it just doesn't make sense anymore. Not only that, if you look at the arbitration clause in the credit card agreement, most of the time those fees cannot be assessed to you. I actually just litigated a case in an arbitration case where I did, where the creditor tried to get the arbitration costs awarded to them, but the clause in the terms and conditions of the credit card agreement actually state that the creditor is going to cover those unless there's just something where the arbitrator finds that there was just, that it was filed in bad faith, which, that's very rare that something like that's going to happen. So I would say probably anything under $3,500, I would be surprised if they would want to continue on with arbitration. But that being said, sometimes I see weird things, but that's generally what I think.
Okay, great. So you're saying that's a rough ballpark of when people might continue on?
Yeah.
Okay. Further follow-up from Tiffany. If the suit is from a company that bought the debt for a fraction of the original amount, would arbitration result in a settlement close to the amount they purchased it for or the original amount?
Well, the amount, and I get it that it's easy to focus on the amount that the debt buyer paid for it. I can tell you in most situations, whether it's court, arbitration, that's not directly relevant. I know in Arizona courts where I practice, they don't even require them to disclose how much they paid for it, just that something was paid for it. And so I understand that, and it's easy to focus on it. I wouldn't focus on that as far as settlement goes. I would look at the total amount. It does impact it, though, in that you're at least generally aware that they didn't pay. If they're suing you for $10,000 they didn't pay $10,000 for this. So you know that they will take considerably less than this. And junk debt buyers will settle for less than an original creditor will in most circumstances because of that. So I would still, you're going to have to start with what they say is owed, because if they prevail, whether it be in a court hearing or whether it's arbitration, if they prevail, they're going to get the full amount, not just what they paid for it. And so I think you still need to start there in your negotiations and make your settlement offer, based on that number, not what you're anticipating that they paid for it.
Is arbitration more like mediation, where it's likely to result in a situation that's in an outcome that is kind of a mix between the parties' interests, or is it more like court, where it's likely to result in a winner-takes-all situation?
Yeah, no, I think that's a good question. It's a winners-take-all type thing. It's much more relaxed than a trial process, and there's not as much discovery as far as what you're able to do there. With AAA, the arbitrators I've dealt with recently, they all want to do it via Zoom. None of them want to do anything in person. And the rules of evidence typically don't apply. And so things are a little more, especially for lawyers, it feels a really kind of loosey-goosey, as far as what they're allowing in. So it's not something where they're going to find some middle ground or broker a settlement like in mediation. It's going to be all or nothing. You're going to win completely and owe nothing, or you're going to owe whatever amount that they can actually prove.
Right. Okay. Yeah. So there's a winner and a loser when you come out of arbitration.
Absolutely.
Right. Something that, a question that's come up for us recently from customers is about affirmative defenses in the answer. Can you tell us a little bit about what is an affirmative defense, and as a lawyer, what do you do? Do you list all affirmative defenses available? Are you tailoring them to the consumer's facts? How's that work?
Yeah, affirmative defenses. So when you draft an answer, whether you're using solo suit or whatever it is, you're going through and you're responding to the numbered paragraphs, really stating whether you admit or deny the allegations. And then beneath that, in most jurisdictions, you can list any affirmative defenses that you have. To me, it's easier to understand what affirmative defenses are, like in the criminal law context. I always say, if someone's accused of murder, they might say, yeah, I did it, but I have a defense of self-defense. So essentially, you're saying, yeah, even if everything that the creditor is saying is true, I still have this defense that I can assert. So in the criminal context, yeah, I did everything that they're alleging, but I have this affirmative defense that it was a self-defense. You have these affirmative defenses in civil cases as well. Like a big one is statute of limitations, where essentially you're saying, yeah, even if everything that this creditor says is true, the statute of limitations is expired, and so they can't pursue it. Or if there's payment that's been made, or I even include to your point, sometimes you'll see attorneys will just put any imaginable affirmative defense. I don't typically do that. I know why they do that, because in most jurisdictions there's case law that if you don't plead your affirmative defense in the answer, you've waived it, which is always a weird rule to me, because usually through discovery you become aware of additional facts, or maybe you realize that there are affirmative defenses. I don't usually list everything. I usually list statute of limitations, even if I think it's pretty clear cut that it's within the statute. I do it just in case something comes out. I don't know if it's technically an affirmative defense, but I do put in there if the case is subject to a private arbitration clause. I just put it in there because there are some arbitration clauses where they want you to put them on notice. If you don't put the other side on notice right from the very beginning, some courts say that you waive the right to do that. So I usually put that one in there. Or if there's been payments, like if you've made partial payments that you think they're not crediting you for, you can allege the affirmative defense of payment. Latches, I've alleged latches before, which is kind of the sister argument to statute of limitations. So I'm pretty limited. I don't go overboard with that or just list everything imaginable. I tend to do things that I think are going to be relevant to a debt collection lawsuit. Usually it's statute of limitations, and then just at least noticing them about the private arbitration clause.
Interesting. All right. Yes. Statute of limitations, arbitration clause, sometimes latches.
Yeah.
Fantastic. And then beyond that, it's tailored to the consumer's facts.
Correct.
Right. Okay. Great. Kia, is it worth the time to file an FCRA complaint on a landlord who, after you filed a complaint with the city against them because of habitability, then filed for eviction against you, to which a judge then granted the landlord $1,000, and then the landlord put it on credit card, they added an extra $3,000 to the $1,000 they were allowed? It's quite the question.
Yeah, so the Fair Credit Reporting Act, which is the federal statute that deals with how creditors report information on your credit report, credit bureau, which is the credit reporting agencies like, TransUnion, Equifax, Experian, those guys. I don't do a ton of FCRA work. I know a prerequisite to the FCRA claims, if you feel like there's a lawsuit, you have to file a dispute with the credit reporting agency. That's a prerequisite to filing suit. So I recommend, if you think that something's inaccurate, I think it's worth your time disputing it on your credit report. The way that it works, you dispute it. You can dispute it online. All three of those, the big three credit reporting agencies, you can do it through their system. You can also mail something in. If you go to their website, they have a mailbox where you can mail it to them physically. In most cases, I think the online one will work. I mean, there are situations where we do physically mail it in, but usually it's something where you can do it online. And then the credit reporting agency and the creditor then have 30 days to respond to it. And if the creditor doesn't respond within 30 days, the credit reporting agency, the TransUnion, Equifax, Experian people, they have to update it or delete it completely. And so it may be a way to deal with it and get it done with, taken care of completely, maybe a way to get additional information. Or if they leave it on there and you still feel that you have an FCRA claim, then you can take it to an attorney and say, look, I've already done this first step. Now we can actually bring a suit against them. So I don't know with those specific facts if you're going to have an actual claim, but I think that first step is an important one, because otherwise, if you go to an attorney, that's the first thing they're going to do is have you dispute it so that they can move forward on it.
Right. Okay. Yeah. And Kia, just summarizing your statement here, right? You're essentially saying that the landlord over-reported your amount of the debt from $1,000 to $3,000, and you're wondering if you should dispute it. You'd mentioned in your chat specifically filing an FCRA complaint on the landlord. When you file the FCRA complaint, as John mentioned, you're essentially submitting a dispute to the bureau. You're not like suing the landlord for something here. So you'd just be disputing to the bureau, saying, hey, it's not $3,000, it's $1,000. Question from Jackson. I'm being sued by a credit card company. Contracted in 2014 in Arizona. Last payment in early 2022. Living in Utah for the past 5 years. Lawsuit is in Arizona. Well, you hit mine in John's states. John's in Arizona. I'm in Utah. So that's fun. Yeah, what do you think, John?
Was the question about statute of limitations?
Let's see. So he's being sued. The contract is in 2014. Last payment is 2022. Yeah, it doesn't actually frame up a question, but I think he's basically asking, as the statute of limitations expired potentially since last payment was in 2022 and he's in Utah? Okay.
Well, and the issue that we run into a lot of times is which state's statute of limitations is the one that's applicable, because each state, it's different. A lot of times it's very similar. Like in Arizona, it's a 6-year statute of limitation on a credit card. But Arizona also has a statute that states that you can apply the statute of limitations from the place where the contract was entered into. So I've had clients that have moved to Arizona just recently, and they have a credit card that they, somewhere back east that they entered into that has a much shorter statute of limitations, and we're able to apply that. Or even if there's some discrepancy there, Arizona will apply a 4-year statute. So I don't know the Utah ones off the top of my head. But it's something to be aware of. And the factors you need to look at are how long has it been since a payment's made? I mean, if the last payment was in 2022, I don't know any in the country, any statute of limitations that are only 2 years. The shortest like Arizona has a 3-year one for oral contracts, but so I think that you're probably within the statute, truthfully, in all 50 states, if the last payment was made in 2022. But then the other issue, you can look at where you entered the contract. You can look at the terms and conditions. Sometimes there's what's called a choice of law provision in there, and it will state which states' laws are going to be applicable to it. Those are all the things we go to. Statute of limitations issues are actually more complex and kind of convoluted than you may think. It seems like it could be open and shut, but it's not. Some states consider them procedural versus substantive, Erie doctrine. George may remember from first year law school, where, how's the court going to apply that? So those are the factors that I go through when we're trying to determine, okay, here's the state, here's where you moved from, here's what the contract was entered into, and which statute was applying. But it does sound like it's been too recent. If it's only been a couple of years, I think they're well within the statute of limitations.
Right. That sounds about right to me. Sometimes our customers have the question of venue as well. I don't know if you got into that here, but right, about like if they can be sued in Utah or if it should be in Arizona. Is it usually where the consumer, is it usually they can be sued where the contract was initiated?
It's typically where the defendant resides in a consumer case like this. I've seen it in some commercial or some business credit card cases where they'll have a provision in the terms and conditions saying that they can sue you wherever the contract was entered into, or that the case will be in New York or something like that. But if it's just a run-of-the-mill credit card case, it's going to be where the consumer lives. And actually, there's an FDCPA, there's a Fair Debt Collection Practices Act provision that states that they've got to sue you in the county where you actually reside. So if I've had cases in Arizona where actually someone's moved and they've sued them in the wrong court in the wrong county, and the court's actually dismissed it. I mean, they turn around and refile it in the new case in the new county, the proper county. But if they're suing you in the wrong state completely, that's always the danger, because you're in a situation where you may not even be aware of that the lawsuit was filed. So I always say, if there's somebody who's calling you or sending you stuff in the mail, and especially if it's out of state, you need to pay attention to it and see exactly what they're doing so that you don't end up with a default, before it even starts.
Right. Yeah, we definitely see customers from time to time who open a credit card in Arizona, then they move to New York, and they get sued in Arizona. In that case, they bring up an affirmative defense of improper venue. Is that the general idea?
Yeah, that's a great way to get it dismissed. You can get that, like I said, it usually doesn't make it go away completely, but you can get it dismissed. Right. If it's close to the statute of limitations and it's dismissed, it may get rid of it altogether. So,
right. Great. Question from Zamwania. I was sued for less than $2,000 and they quit when I successfully submitted a motion to compel arbitration. Nice work, Zamwania. Sounds like a win. They had to pay AAA $675, even though we both walked away with an agreement to never pursue. No question, they're just kind of making that comment. What is the agreement to never pursue, even though we both walked away with an agreement to never pursue? Are you familiar with that concept?
I mean, there may have been just a general release, like a settlement agreement, or with arbitration, you're not going to get a dismissal with prejudice, meaning it can't be refiled. But one thing I do tell consumers, whether you're in arbitration or whether you're in a court proceeding, sometimes, I've been in a court proceeding and the other attorney who represents the creditor, they'll come in and they'll say, hey, we'll just dismiss, we'll walk away. And they may even say, we'll dismiss with prejudice, meaning it can't be refiled. That's great, but you also want them to sign off on a settlement or a release saying that they're not going to continue to pursue the debt. Because I've seen it where they'll get rid of the lawsuit, but then they'll still extending you letters and trying to get you to voluntarily pay it, or they may even transfer it to a new debt buyer, and you can run into some issues there. So if you're able to get, like in this question here, if you get a settlement, it sounds like there may have been a general release that both parties are saying, yeah, this is done. You can't come after me. You can't send me letters, nothing like that.
Great. Question from Brackamy. I went to court today and they used my solo suit forms when I filed my answer in my arbitration, and they have granted me moving to arbitration, but the debt collector attorney wasn't there. Is that what should have happened if the collector wasn't there?
I mean, typically if they don't show up, I mean, and I thought you said in the question that they did grant it. So, I mean, the way that the courts treat motions in most situations, if you file a motion and it goes on, there's no response to it, the court deems that as acquiescence to it being granted. And so if they don't show up to the hearing, it doesn't surprise me that the court would grant that. I mean, that's what you would want. And I actually fight for that. Sometimes I've had judges who say, well, we'll continue this. And I always respectfully say, no, if the shoe's on the other foot here, judgment would be entered or default 100%. Would be entered. And you got to say that in a polite way to a judge, but often they'll agree, that if you didn't show up, the judgment would be entered against you. If the creditor doesn't show up, whatever you're asking for should be granted as well.
Right. If you show up and the collector doesn't show up, as you mentioned, if the situation was reversed, there'd definitely be a default judgment entered against the consumer. Is there a way to ask for just a dismissal of the case altogether if you show up? This is probably a hearing for the motion, I would suspect. But if you show up and the collector just doesn't show up, you need to try to get the entire case dismissed?
It depends on your jurisdiction. There are hearings in Arizona, like a pretrial conference. If you show up there and the other side doesn't, they warn everybody ahead of time. Judgment could be entered if the consumer doesn't show up, or if the creditor doesn't show up, it can be dismissed. So it never hurts to ask. That's what I always say. I mean, if you show up for a hearing or oral argument, like on a motion to compel arbitration, and they just don't show up, you could just do an oral motion of saying, hey, we're going to move to dismiss this for failure to prosecute. It's their case. They're not here. The court may deny it or the court may continue it out, but they may grant it as well. So I always say, if they're not there, I always move for that, for failure to prosecute. And some courts, in most jurisdictions, these collection cases are second only to traffic tickets. They just clog the court system up, and a lot of judges are like, if the creditor's not going to push their case, we'll get rid of it and move on to the next. So I always say to ask. It doesn't hurt to ask.
So if you're in that spot and the collector doesn't show up, you can say, Judge, I'd like to make a motion. I'd like to make an oral motion for lack of prosecution to dismiss the case, essentially, right?
Oh, yeah.
Yep.
Or worst thing the judge says is no.
Yep.
So might as well.
Yep. I think it depends largely on the judge, right?
Yeah.
In that situation. All right, this next one's a doozy. We got a question from Death.
Oh, wow.
Yep, literally just
serious.
Death. I don't know if that's like a Discworld fan. I would hope that would have expected the comment to be in all caps if the user here is a Discworld fan. I'm currently being sued by LVNV. I went to the first hearing to dispute it. I'm waiting for them to send a bill of particulars. Is there any other document I should ask for? This is such a mundane or polite question from Death.
Yeah. Yeah, I expected something much more vicious than that. But, I can say that the documents they need to have to prove their case. I mean, so LVNV Funding, we got a junk debt buyer. They have to prove really three things. They have to prove that you had the original contract. They've got to prove that you breached it. I guess there's four things. So the original contract, they've got to prove that you breached it. They've got to prove their damages. And then they have the burden of proving also that your particular account was transferred or assigned to them. They've got to show all four of those. And so they've got to have documentation to support that. And so here's my little caveat. I think I've said this before, maybe in our live streams. I always say more is less, or less is more. They bear like LVNV Funding, they bear the burden of proof. They've got to establish all four of those elements. You don't have to disprove anything as a consumer. And so if they don't have it, or if they haven't disclosed it, I always say, I don't know why you'd ask for it, because if you ask for it, they may go find it, even if they don't have it. They may have to go back to the original creditor and get all that. Whereas if you show up to trial and they haven't got any of those documents because they're expecting that a self-represented person's not going to, hold their feet to the fire on that, I think it's a situation then where you're in a better spot because they don't have the evidence they need to be able to prove their case. And so that's why when it comes to requesting and discovery from the defendant side, I don't do a lot of discovery. I don't think there's really any benefit. To me, the less information, less documentation they provide, the better it is for me, because they have to prove all the elements of the case, not us.
Great. Okay, we've got a few minutes left here. I'm going to try to go into a little bit of a lightning round and just kind of run through some of these questions and try to give some short answers here. Got a follow-up from Brackamy. I called the third-party debt collector to settle for 20% of the settlement amount. Previously it was 50%. Looks like I have the power now. Okay, that sounds great. Let's see if we can find some with actual question marks in here. We got a thank you from somebody. That's great. Okay, we got Barry. Served by Stenger and Stenger, LVNV for credit card debt. Paid $100 towards debt to Stenger through their online option. Still need to file an answer. Does this affect negotiations? Also, I'm disabled. Yeah, I'd say that definitely affects negotiations. So for one, making a payment at this point will renew statute of limitations if the statute of limitations was already expired. Also, beyond that, it doesn't necessarily put you in the bad spot for negotiations. You definitely want to file an answer and then try to negotiate, because filing an answer will give you more leverage to settle. Sven, I'm being sued by LVNV and went through solo suit with a response to them for further proof, and they sent me a package of my statements from a year ago. What are my options from here? Do I settle? Yeah, so it sounds like you filed an answer or a response. You want to make sure that you actually filed like our answer document in court. They responded with statements, so you can certainly try to settle still. Most people want to try to settle. You can make an offer to settle on solo settle. Sending statements to the consumer directly at this point, is that a normal thing in your experience, John? Sounds like we have a line in the answer that requests an accounting of the debt. Is that normal? Is that something that would be filed in courts, or what's going on there?
Well, I mean, usually where I see the bulk of the statements is after the answer is filed. Most jurisdictions require some type of initial disclosure where any documents that they have in their possession, they've got to provide you copies. So like in Arizona, we have to get those 30 days after the answer is filed. And so often I'll get a big stack of monthly statements or something like that. I also see, sometimes people will verify the debt. I know through solo suit you can request a verification of the debt. Sometimes you get a couple statements, sometimes you get a big stack of statements, depending on who the creditor is. So that's typically where you see it. Or if you do a request for production of documents through the discovery process, they may provide you with a copy of those as well.
Great. Question from Shanique. How do you have old debt removed from case search? Kind of weird to me that convicted criminals can have expungements but paid and expired debts can't be. Interesting question. Is there a situation, is there like because a debt judgment, if you have a debt judgment against you, it'll be on the books indefinitely. Is there a way to get that removed?
That's going to be a state-by-state thing. I know in Arizona, I mean, you could petition the court to have it removed. I was actually just doing a case search today, and I saw one where I looked up a client name, and it was sealed. I couldn't see what was in it, but I could still see that the case existed. Same thing with like civil judgments. Usually the creditor records them, like with the county recorder, so that it acts as a quick lien. But even once you pay it, it doesn't go away. They just have to file a release or a satisfaction with the county recorder as well. So it's a good point. In the civil realm, it's kind of difficult to just make it go away completely.
Yeah, it is a good point. I think the reason there's an expungement is because criminal cases will have more of an impact on your life than a debt judgment, but the debt judgment can definitely have an impact on your life as well. I think the main thing is to try to get a motion to satisfy judgment, or like a record that the debt has been quote unquote satisfied, meaning it's been paid.
Yeah.
Okay, just jump into some of the most recent questions here. We've now gotten through all of the questions that were on before we started the webinar. So, so there's a lot of questions today, folks. All right, we do this once a week. So come back on next Wednesday if we haven't gotten to your question. Just wrapping up with this one of the questions here from the most recent part of the chat. B's Chaos. So I filed an arbitration. So I filed an arbitration complaint and I got granted. I offered a 30% offer and they declined and giving me also 90%. Should I go file it?
So they filed the arbitration or no? I didn't catch that.
Seems like they filed an arbitration. Yep.
Yeah, if the court grants your motion to compel a private arbitration, to me the leverage comes when you file it, not just the fact that it was granted. Because until you actually file it with AAA or JAMS or whoever you file it with, there's really no obligation for the creditor. So I think it's a good next step.
Right. Yep. Get that thing filed. All right, folks. Thanks for coming on. I wish we could have gotten to all the questions, but there's a lot of folks here. There's a lot of questions. If I didn't get to them, hopefully Hannah, our wonderful assistant, got you some answers. And you can always come back next week. All right. Very good to see everybody. Until next time, take care.